morning. The next case to come before the court is State versus Wheeler. And both sides receive 15 minutes apiece. Mr. Wheeler, we're scheduled to start at 10:30, but you still will have 10 minutes left. If you would like to reserve a couple minutes for rebuttal, you're allowed to do that as well. You may proceed.
You need to come up to the podium.
I'm sorry, yes. Thank you.
Sorry, first.
Right here, that's fine, yes.
The crux of this case, systematically from the onslaught, has not been one based on truth and justice, but one based on a witch hunt and based around the prosecutor's way to manufacture another case in the name of domestic violence in order to simply appear to put another feather in the state's cap, so to speak. One cannot help but observe the inconsistencies which leap out at one upon examination of all the facts surrounding the litigation and prosecution of this particular domestic violence case tried in the municipal court of Medina. Where domestic violence is not to be taken lightly, one must be cautious as to never let overzealousness affect one's judgment and whether a case is a valid prosecutable case which has the alleged victim and perpetrator legally and lawfully, and I might add, as the biggest part, properly identified. In a case as serious as this one, with the potential to label a man or a woman with the branding of domestic violence, which in our society today serves as a scarlet letter, causing potential employers and society as a whole to ostracize and label that party a monster. It is incumbent the prosecution explore all facts and not just the alleged facts leading up to the arrest in order to determine the validity of all claims and charges levied as being factual and truthful while vetting the authenticity of any and all alleged victims or stated witness prosecution intends to use in the trying of that particular state's case. This should have been done to protect the validity and sanctuary of our legal system, which must ensure there are no innocent parties being charged with the crime they did not commit. In a case where the state of Ohio is to automatically pick that case up, it is incumbent as the last line of defense in truth and justice that the prosecution for the state explore every possibility as to whether or not they have in their possession a legal and lawful triable case with a legal and lawful victim and a legally and lawfully prosecutable perpetrator. We are here today, be it at my dismay and disbelief, given the facts surrounding this case, to prove that the 5 listed prosecutors or assistant prosecutors listed on this case, known by the names of Richard Barbera, Gregory Hubert, Jay Lanier, John Quinlan, and Michael John, have all gathered under this bogus and manufactured case, not in the interest of justice, or even to admit, quite frankly, that a grievous error was made in prosecuting this case. Upon hindsight given, the opportunity to take a full look at the lack of cooperation given to the state of Ohio by the alleged victim/witness that this case was centered around. It would be, or quite possibly would have been remarkable to show up to these proceedings and hear the words, "We made a mistake in moving forward with the prosecution of this particular case." Given that we had a chance to later discover about the willingness and lack thereof of the alleged victim/witness involvement in this case. I intend to show today that the state of Ohio not only moved forward and rushed me to judgment, but that the state of Ohio, through Assistant Prosecutor Barbera, did so knowingly without a cooperative and truthfully willing victim/witness. And even with the opportunity to gain a better perspective on whether or not the state had a truthful and willing victim/witness, prosecution chose to use extraordinary means seeking to gain a conviction on a case that was at the very least a nullity or dismissible case for one of prosecution. And according to the very direction of orders, easily perceived as a threat, duress, or coercion, aimed at the alleged victim/witness given by Judge Dale Chase of the Medina Municipal Court of sanctions amounting to contempt of court or filing false charges in order to extort the alleged victim's unwilling participation as a witness for prosecution. I'm not only here today to simply put all the blame on prosecution, but I'm here today to prove prosecution could have voluntarily put an end to a case that had all the signs of a false claim against an innocent party being held accountable for a crime he did not commit.
What about was there testimony from the officer who responded that there were injuries on the victim that were consistent with some physical violence?
When the officer arrived at my residence, I was standing outside in the garage. What happened that night was my wife previously had been absent from the house for days and weeks at a time. She had a drinking, an alcoholic abuse problem. She had recently received an OVI, which I helped her negotiate in Brunswick. When I started questioning her on what she was showing our minor child, as far as not being at home and as far as always hitting our minor child, she began hitting me, and I put my hands up to block her. In the event of
wait a minute, did you testify at the trial?
I testified at the trial, and I also had 4 character witnesses to testify that had been around our relationship to attest that I have never even spoken loudly or out of place to her, let alone put my hands on her.
And along those lines, a lot of the argument that you're making in the brief goes to whether or not there was sufficient evidence or whether she was a credible witness. But the city has indicated that no transcript of the trial was filed in court for us to review. Is that a fact?
I was not aware. I was under the impression that there should have been a transcript filed.
Well, that would have been your responsibility as the appellant to file a transcript. And without a transcript, we can't consider what was said because we don't have a record of it.
Okay.
But you can go ahead with your argument.
Okay. The facts of the case. On December 27th, 2012, Rosa Wheeler made a 911 call. Fact number 2, Patrolman Salvador responded to the call and first came upon Eugene Wheeler, Jr. I in the garage of the residency located at 1296 Riverwoods Drive. Fact number 3, Eugene Wheeler filed an affidavit with Patrolman Salvador and asked that Rose Wheeler be arrested for domestic violence committed against his person. Fact number 4, Patrolman Salvador did commit a warrantless arrest of Eugene Wheeler and did not immediately take him before a judge or a magistrate to get the arrest warrant to detain him. Fact number 5, on 12/28/2012, Eugene Wheeler was arraigned. On 12/28/2012, a temporary protective order was issued against Eugene Wheeler, barring his person from 1296 Riverwoods Drive, a property not subject to marital property, but a property of an estate to which Mr. Wheeler served as trustee. On 12/31/2012, Rose Wheeler voluntarily showed up at the temporary protective order hearing and testified she did not choose to have nor felt she needed a protective order, so the temporary protective order was terminated. A bench trial was set for February 7, 2013. A day before trial, Assistant Prosecutor Barbera sent a patrol car to the residency of the victim, as well as I, as we were still residing together, to check on her well-being and to see why she's rebuffed all attempts to communicate with Assistant Prosecutor Richard Barbera in his overzealous, unsubstantiated prosecution of this case. The officer informed Rose Wheeler that she needed to be present the very next day as the case was commencing as a witness for the state.
Mr. Wheeler,
Yes.
if you want to reserve any time at all, then you need to stop. If you don't care about reserving time, you can continue with your argument.
Okay. I will I will continue.
Okay,
I will
go ahead.
continue. On 2012, on February 7, 2013, the victim was not present for the trial created by her own false claims of domestic violence, in which Eugene Wheeler moved for an immediate dismissal of case number 12CRB018846 for one of prosecution citing Crawford versus Washington. A spouse cannot be compelled to testify against the other if it is not their choice to do so. Though Patrolman Salviter testified at the roll call meeting of the officers' meeting at the station to the fact that Assistant Prosecutor Barbera sent a patrolman out to our house to check on her well-being and informed her, they did not have that officer present to offer his testimony. The initial trial of February the 7th, 2012, Patrolman Salviter was present as a witness for the state. The case was reset for another bench trial under protest and objection of Eugene Winston Wheeler Jr.
And Mr. Wheeler, you need to wrap up because you're out of time.
Okay. Patrolman Salviter was instructed by Judge Dale Chase alongside the Deputy Sheriff of the court to well, I'll just move to the end as I'm forced to wrap this up.
Thank you, I appreciate that.
I say Crawford versus Washington is a case that has been established that the courts cannot compel or profit from the extorted testimony of one spouse against another regardless of the marital status. I'm hereby today seeking justice for my person, but the true fact of the matter is, regardless of the findings here today, my 12-year-old daughter was always a party and subjected to the domestic violence at the hands of her mother, who thankfully no longer is in the household, and my daughter who attempted suicide in 2014 due to the excessive abuse directed towards her and by her mother, gained liberation through the Medina Court of Common Pleas with domestic violence case 14-DV0056, which accorded a protective order of 1 year as of May 19, 2014. And though the final divorce decree was issued March 10, 2015, giving Eugene Wheeler full custody of his daughter solely. So at the very least, my child has benefited from our judicial system, and in fact, if I have not proven beyond some semblance of a doubt that the alleged victim has had false charges levied against me, who was in fact never in danger of domestic violence or abuse and never incurred domestic violence or abuse at my hands, though inflicting harm on numerous occasions against my person and our 12-year-old daughter, or if the court is not satisfied that the alleged victim's own actions or lack of willingness to cooperate with prosecution, let alone to invoke the protective order offered, is not circumstantial evidence to support the fact that she could have possibly lied in placing the 911 call while never communicating with prosecution leading up to the original trial or even appearing at the original trial February 7, 2013, and only after the facts, until threatened with possible sanctions, did she show up at a second unlawfully scheduled trial, and trial is not proof positive. She was never the victim. She wanted the courts to believe she was. Then I say justice has not been served and the foundation of our forefathers established has not worked as it was intended to, but I will not stop believing, and to that I can only say, in God we trust, but in man we hope we can trust.
Thank you, sir. You may proceed.
Thank you. May it please the court, Mr. Wheeler. There is a perception in the general population that when you have a trial, if you get an adverse result in a trial, you can appeal it as if it were a second trial or a second swing at the issue. And that's what is commonly believed. And I can recall as a practicing lawyer when someone would want to appeal, and I would say, well, what did the judge do wrong? What did the judge do? Well, the judge didn't do anything wrong, but it was unfair. No, see, in an appellate court, I would explain what did the judge do that was wrong, because that's what the Court of Appeals is really reviewing, the judge's actions. In this particular litigation, in looking at the pleadings and so forth, I thought, and put in what I thought the issues to be presented was the appellant afforded a fair trial, and secondly, did the appellant provide enough of a record for this court to grant him the relief that he seeks. Appellate work can be complicated, and it's somewhat specialized, and there's resources that you have to refer to, and there are rules that you have to follow. When the appellant doesn't provide you with a trial transcript to say what was going on, how would you be able to determine whether the court did or did not make a mistake? The arguments, as I understood them to be, were manifest weight of the evidence, was sufficiency of the evidence and manifest weight of the evidence. I explained that in the brief. I think the court found both of those things. There was a trial in this matter. I mean, this was tried. One of the complaints of appellant, as I understand it, is the trial was set for one day certain and was continued by the judge because, at the request of the state, because perhaps of a missing witness. But I would submit to the court the judge can do that, and it's up to the judge, and the judge has the discretion to control his own docket, and he can reset it if he wants. And it may seem like if they don't show up on the day, you win. If they don't show up, you win. That may seem to the unenlightened, those that are not in the business, so to speak, that ought to be true, and then yet the judge can do that. And it was reset, and there was a trial, and there was a verdict. So I would suggest to this court that Mr. Wheeler's unhappiness is genuine, but he was in fact afforded a fair trial. And he has in fact not presented to this court the sufficient evidence to overturn or to review really the judge's actions. And I'm addressing the court, and I appreciate that. And I would say, because I know Mr. Wheeler's here, we had a case. The city had a case in which there was it was an OBI case, and there was reference to a judicial notice of the NHTSA manual, which we did not, as the state of Ohio, we didn't provide to the court. And the court's proper ruling was, without that in the record, we can't tell whether the field sobriety tests were right or wrong. I bring that up because even the state, even someone who's in the business like me, I messed that up, see? I did not provide the Court of Appeals with sufficient information to allow you to overturn whatever the judge had said. I offer that only as an explanation that the rules apply to everyone, and the state of Ohio has both benefited and suffered because of a failure to follow those rules. And I appreciate that, and I appreciate the court's attention. If you have any questions, I'll do my best.
I don't believe there are any.
Okay, thank you.
Thank you. Thank you both, gentlemen, for your presentation to the court, your arguments that were made today. The court will review the record and will make a determination and issue a written opinion. And that will be sent to both of you. And you also can look on our website, and you can look for the release of the opinion that way as well. Thank you.